Good morning, everyone. We will get started shortly. We're just waiting for everybody to enter the webinar. So please be patient and we'll get started real quick. Thanks. Okay, welcome everyone. We can get started now. Welcome to Protein Industries Canada's IP 1.0 webinar presented by in partnership with MLT Aikins. And my name is Carson Sinclair. I'm the program coordinator at Protein Industries Canada. I would just like to take you quickly through a couple of the features of Zoom webinar so that you are familiar with it ahead of this presentation today. Audio settings can be found on the toolbar on the bottom left-hand corner. If you're having any difficulties, check there first to work on some of the audio settings. Secondly, we have the chat feature that you can use to talk with myself to help with any other technical support. We are asking people to hold questions to the very end of the presentation. We'll do a roundtable and a moderation of questions. We ask that any questions that you have for the presenters to be entered through the Q&A feature. You will see the Q&A feature along that bottom toolbar as well. There is a upvoting feature within the Q&A. This works as a like. So if you notice a question on the Q&A that you too would like to have answered, the more likes a question has, the higher it goes on the list. So it helps us curate the most widely asked and popular questions to answer. And once again, this webinar will be recorded, so we will be able to share it with you after, and presentations can be made available after the webinar as well. I'd like to introduce now Megan Gervais, our IP manager, to welcome us and kick off the webinar. Megan.
Thanks, Carson. Welcome, everyone. Thank you for joining us today. I'm really excited to be back with a presentation around sort of the intellectual property fundamentals, and pleased to be joined today by Crystal Allen, who is a partner with MLT Aikins. Crystal is located in Calgary and has assisted us with presentations related to intellectual property within the past year or so. Crystal's primary practice area is with regard to advising clients on the development, management, and commercialization of intellectual property assets and new technologies, which of course positions Crystal really well for the conversation we're going to have today. In addition, Crystal also advises extensively regarding risk management, privacy, and policy development related to data sharing and electronic documents. So with that, I will pass it over to Crystal for her portion of the presentation. We'll start today talking about the IP content of the presentation, and then we'll close it out with some specifics around how all of this plays into Protein Industries Canada and the work that we're doing. So Crystal, over to you.
Thanks, Megan. I'm just going to share my screen, so bear with me for a moment while I do that. Okay, I'm assuming that you can see that. Just give me a thumbs up.
Great. Looks great, Crystal.
Perfect, just making sure. Okay, good morning, everyone. Thank you for attending today. Really appreciate you being here, and I trust that you'll intake some useful information today. I just want to say at the outset, just kind of laying the groundwork for what we're talking about today. As Megan mentioned, this is an IP fundamentals webinar. So what that means from our perspective is that the focus today is to provide some information to you to help you basically obtain a greater understanding of intellectual property kind of at a high level. So what is intellectual property? What are the key forms of intellectual property? What are some questions that you should ask when you're thinking about intellectual property and its management and protection in your own organization? And then what are some sort of tips and traps or common mistakes to avoid when dealing with IP? If you do have questions about IP or want to learn more about IP, kind of at a more detailed level, including a lot more about how to manage and oversee and address more detailed kind of commercial intellectual property issues, I would note that PIC is also offering an IP 201 or 2.0 webinar in October that will dive deeper into that. So this is our introduction, and then the deeper learning comes in the second webinar. So I'd encourage you to also sign up for that if you'd like to learn a bit more. But in any event, let's get started. So what do we want to accomplish today? What are our objectives here? We really have three primary objectives. The first is to help you increase your understanding of intellectual property. The second is to help you understand how to apply intellectual property in the context of the agri-food value chain. As an agriculture or food-based organization, and how to understand and think about using IP in that particular context. We also want to introduce today, and as I said, we're just doing this at a high level today, and more detail on this is available in the second webinar in October. We want to kind of introduce that framework that you should use when you're thinking about how you might want to approach intellectual property and its management within your own organization. So I just want to stress that this is kind of a general overview. The answers to the questions of what should I do about IP in my organization, how should I manage it, are sort of not one size fits all. It's very organization specific and quite frankly, very technology specific. So what we're hoping to do today is help you ask the right questions, and the answers to those questions will depend upon the context in which you're asking them. So let's dive in. So starting off, it's always useful to just think about what are we talking about when we're talking about intellectual property. I've included for you here three different definitions that I think capture the essence of what intellectual property or IP actually is. One is kind of a technical definition, from the World Intellectual Property Organization, or WIPO. The second is an academic definition taken from a university here in Canada. And the third is what I would call a more modern, practical, tech-driven definition of IP, taken from our friends at Shopify. But essentially, regardless of which definition kind of resonates most with you, when we're talking about IP, we're really talking about those concepts and ideas that are conceived of or developed by employees, consultants, advisors under contract to develop IP that become corporate assets of an organization. So those include, from practical perspective, things like inventions, processes, articles, blog posts, case studies, books, illustrations, photos, music, logos, reports, movies, games, taglines. All of those things are different examples of intellectual property and are handled a little bit differently. Okay. When we're thinking about intellectual property generally, and we have a grasp of sort of what that means, it's also useful to think about within that broad definition of intellectual property, what are the different types of intellectual property we can actually have? So I gave you some examples of what might fall within the bucket of intellectual property, but each of those things fits within a different category. So the most common types of IP that come up in the context of that agri-food value chain are, as I've listed here on the screen. We have patents, which really a patent is a legal monopoly granted in exchange for the disclosure of an invention. So when you receive a patent on an invention or on a new technology, what you are receiving is kind of an exclusive right to make, use, and sell that invention. and that right is jurisdiction specific. You have the patent in Canada only. Copyright, on the other hand, is a form of intellectual property that really grants or confers a legal monopoly on an original artistic work. So something like a song or a movie or an episode of a TV show also would include something like a book or a report. Copyright arises automatically upon the creation of the original work, and an application for and registration of copyright is not necessary for it to exist. A trademark, on the other hand, is something that is used to protect an identifier of goods and services. So something like a logo or a distinctive design or mark that is used to identify a product or service and differentiate it from other comparable products or services on the market. A trade secret is something that is really focused on valuable, commercially valuable, I should say, secrets or confidential information. It's really confidential information that only you or your organization possess, and that you have only disclosed outside of your organization under an NDA. It is valuable and has value only because it is secret. Finally, plant breeders' rights. Obviously, this is one that's a bit unique to the agri-food value chain and doesn't have much application outside of that, but it's an important one for us to be aware of and cognizant of. This is a protection that's available to plant breeders for new varieties, which provides for exclusive rights over sale, production, reproduction, import, export, stocking, and conditioning of propagating materials of a plant variety. So let's dive into each of these in a little bit more detail. Give you a more fulsome understanding of what each form of intellectual property that we're talking about today actually is. So when we're thinking about patents, we're most often thinking about tangible inventions or technology that we've developed, like a new piece of machinery, a new process for creating a product. These are the types of things that most commonly are thought of and relevant when we're talking about patents. So patents protect inventions, and inventions have a specific definition in our Patent Act in Canada, but they really are encompassing things that are new and useful, sort of, as I said, processes, machines, compositions of matter, or any improvement in any of those things. A patent is, when registered, a grant of rights that allows you as the patent holder to prevent anyone else from using your invention that is the subject of that patent for 20 years, unless you give them permission to use it under something like a license. After the patent expires, that invention is no longer protected and anyone is free to use it. In order to be patentable, though, an invention has to meet 3 criteria. So not all inventions are patentable just because they are inventions. They're only patentable if they meet 3 criteria. And those criteria are: 1, novelty. So the invention has to be new. It can't have been created before and it can't be already existing. Secondly, the invention has to have utility. So it has to be useful and have a purpose. Typically that means it has to kind of work, do what it says it does. And finally, the third criteria is that the invention has to be non-obvious. This really means that the invention has to actually be a technology that involved an inventive step. So it took someone actually thinking about a problem and how to solve it, or how to innovate in a certain area. It can't be something that would have been obvious to everyone and that didn't really require that inventiveness to create. Novelty is the key criterion of these 3 that is often misunderstood. And I just want to be clear on this, just for your own benefit. Expressing and displaying novelty to support patentability is more than just the invention being new. It's also about the invention not existing in the public domain previously. So not only is that invention new, but people don't know about it. You've kept it confidential, it's not in the public domain, and therefore, when an application is made regarding that invention, it may be patentable. So I'm going to show you a couple of examples of patent documents, and we'll sort of talk through what we're actually looking at there. First of all, I'm going to show you a patent drawing that accompanied a patent application for one of the most famous patents of all time. If we were in person, I would kind of canvass to the room to see who can guess what this is. This one's pretty obvious, I think. Here we're looking at the drawings for a Lego brick. This is a patent that was granted in the US back in 1961 to an individual by the name of, and I'm going to try to pronounce this properly, Gottfried Christensen. So this was sort of the genesis of those lovely Lego bricks that we all know and love, or if we are parents, step on regularly and injure ourselves. But a very well-known patent, and one that really created value for the inventor. In the context of food and agriculture in particular, I'll give you another example. So here, you may very well have absolutely no idea what you're looking at. This isn't as obvious as the previous example. So here we're actually looking at a more modern example of a patent. And this is a component of the patent drawings that accompanied the application for a Canadian patent issued to a company by the name of Decisive Farming for an invention described in the patent as variable zone crop specific input prescription methods and systems therefore. So this is really describing a process. And this invention, practically speaking, in a commercial world, is actually known as Optimize RX. And it's really just a variable rate technology program. So two very different examples of patents, one a bit older, well-known, one very new, less well-known. So let's talk about copyright. So when we think about copyright, we're thinking about those creative or artistic works. So things like movies, TV shows, music, poetry, literature, art. But creative doesn't just mean creative in the sense that we typically think about, like creative artists, for example. Creative also comes up in the context of writings that were sort of created by an individual or an author. Copyright also has relevance and is applicable to things like software, which often surprises a lot of people, but really that's because software itself is an expression of function through code. So the computer software that is protected by copyright, what's really protected there is the sort of code that actually provides instructions to a device to do something or to display a function. So copyright is often used as the primary method of protection for computer software. Copyright does not protect ideas, it protects the expression of those ideas in a creative work such as a writing or a drawing. So for example, it is entirely possible for two similar ideas to exist and be expressed in written form, but not have those two ideas actually be infringements of each other's copyright. So just to give you a concrete example of that, we all know of two different TV shows that exist and I think are still currently running on TV that are based upon the idea of a dysfunctional animated family with a bumbling sort of father figure and a mild-mannered homemaker type mother figure. Very similar ideas, lots of similarities on every level in those two different TV shows, but they're expressed differently by each TV show. Those two TV shows that I'm talking about are The Simpsons and Family Guy. Very similar ideas, different expression, and it's the expression that is the subject of that copyright. So a copyright can be registered if a copyright owner or holder chooses to register that copyright, but it does not have to be registered. Copyright arises automatically upon the creation of that creative or artistic work, and whether it is registered or not, it continues for the lifetime of the author plus an additional 50 years. So I'll give you some examples of copyright. Again, a really, really well-known copyrighted work is Harry Potter. This one I understand acutely, given that I have a child who is currently obsessed with Harry Potter. This is one of the best-selling books of all time. And the fact that this is a copyrighted work has allowed the author, J.K. Rowling, to become extremely wealthy through her ability to control the sale and reproduction of this work. An example in the agri-food value chain is this guy, which a lot of you have probably seen. This is a very popular publication in the agriculture industry, the famous Crop Protection Guide, or Blue Book. The copyright in this is held by the government of Alberta, and it is used widely throughout the province, and in some cases even outside of the province. Both are written works, both are subject to copyright. Oops, let's go back. I just showed my hand on that one. Okay, so let's talk about trademark for a minute. Trademarks are really combinations of letters, words, designs, sometimes sounds or even smells that are used to distinguish one company's goods or services from the goods or services of other companies in the marketplace. So they're often used to distinguish similar types of goods or services so that you know that the good, for example, that you are buying is from a particular company. They're used to really kind of create and establish a brand. So trademarks are a little bit of a tricky piece of IP in that it isn't just enough that you have a logo and you want to sort of register that logo with our intellectual property office for trademark protection. In order for that logo to be eligible to be registered as a trademark and to be used as a trademark, it has to be used in association with specifically described goods and services. So you have to actually use that logo in connection with a particular product for it to be eligible to be registered as a trademark. It just, it isn't enough to just have the logo and not use it. There is no requirement that a trademark must be registered. However, registration is in almost all cases highly recommended with respect to trademarks because it creates a presumption of validity of that trademark and a presumption of ownership. So it becomes much simpler for you to sort of assert that that is your logo to be used in association with your products. Registered marks are most commonly indicated by an R with a circle around it, following the logo or the tagline. An unregistered trademark is often referenced by just using a superscript kind of TM next to that logo or that tagline. Now, you might be saying, well, what is an unregistered trademark? Well, an unregistered trademark is really a trademark that arises through consistent use of, for example, a logo over a notable period of time in order to kind of build and create goodwill in a product and reputation. So you can have a trademark that arises through usage. You can also have a registered trademark that goes a step further. So you have that usage, but you actually registered your ownership of that trademark as well. So what is appropriate depends on the circumstances, but in almost all cases, as I said, registration and having a registered trademark is going to be preferred. So I'll give you a couple examples of trademarks here, and you already saw one of them. Oops, now you saw two of them. First one is this one, which we have all seen before. This is one of the world's most recognizable trademarks. This one was originally filed for registration back in 1892. And consistent use of this trademark throughout the history of the Coca-Cola company has resulted in an incredible brand value for the company. that brand value is currently estimated at about $57 billion. That brand value really helps Coca-Cola kind of derive pricing power. When you've got a lot of brand value, you can often charge more for your product because people associate that product with a higher level of quality, consistency, etc. In the food and agriculture space, an example is the one that I inadvertently had pop up for you a second ago. This one. This is one of the most recognizable logos in the agriculture industry. And the value of the John Deere brand is currently estimated at more than $5 billion. So again, we have a long period of consistent usage and an incredible amount of value that has been built and reputation that has been built in those products as a result. Moving on to our next form of IP, trade secrets. So trade secrets are often referred to as know-how. And really what this is special knowledge of how to do something, maybe how to make something, or kind of a skill in a particular area or field. Trade secrets often have a lot of value, but they obtain that value by virtue of being secret. As soon as that trade secret is disclosed broadly or widely, that value is lost. This is often referred to as a form of DIY, intellectual property, in that you kind of create the protection for a secret by keeping it secret. You don't have to do anything beyond that to establish something as a trade secret. You don't have to register it. It's not sort of recognized or protected per se under legislation in Canada, but you have a piece of knowledge that is very valuable to your organization, and you keep that knowledge and that information internal, confidential, secret to the organization and don't disclose it outside of the organization. So I'll give you some examples to help illustrate what this is. Oh, and we've skipped ahead again. First one. Everybody has enjoyed KFC chicken before. What you may or may not know is that the famous 11 herbs and spices recipe used by KFC is one of the most well-known examples of a trade secret in history. Way back in 1962, Colonel Sanders, who was a real person, came up with a unique recipe for coating and breading of chicken. He kept that recipe a secret through a series of confidentiality and non-disclosure agreements used both within his organization and outside of his organization for decades. As a result, it has been surprisingly impossible for anyone outside of KFC to recreate that recipe and to fully compete with KFC's unique chicken. So this is a classic example of a trade secret. And this was likely the method by which Colonel Sanders decided to protect his recipe, partially because it's very difficult to protect recipes under other forms of intellectual property protection, but also because by choosing to keep it a secret, Colonel Sanders did not limit how long that protection could exist for his recipe. So it's just as valuable to KFC today as it was 50 or 60 years ago. In the food and agriculture space, I've just given you a picture of what you might see in a nursery or a greenhouse. Here, I just wanted to highlight for you that although patents exist on many sort of seed industry related products, there are also many that remain trade secrets. For example, innovations in things like parental lines for breeding programs and the like are often maintained as trade secrets. This is because companies don't necessarily want a time limit on their exclusivity for that invention, but also because often these sort of innovations, inventions, processes are not usually sold. And so when they're not sold to someone else, they are very difficult for other people to reverse engineer. So a trade secret might be the right form of intellectual property protection for things like this. Finally, let's talk about, oh boy, I've got a bit of a sticky cursor here today, so just bear with me. Let's talk about plant breeders' rights. This is a form of intellectual property protection that allows protection of proprietary plant varieties in a similar way to protection of inventions via patent, but limited to proprietary or new plant varieties only. A grant of plant breeders' rights gives the holder of that plant breeders' right the ability to, grants them the exclusive right to control production, reproduction, conditioning, sale, stocking of propagating material of that plant variety. It provides that protection much like a patent for a period of 20 years and is granted in response to an application made to the Plant Breeders' Rights Office, not our general Canadian Intellectual Property Rights Office. So it's handled in a different office of our government. What I want to stress with plant breeders' rights is that a plant variety will not be eligible for plant breeders' rights unless it meets 3 criteria. And those 3 criteria are different than what exists for patentability. The first criteria for plant breeders' rights is that the variety must be distinct. So that means it must be measurably different from all varieties of common knowledge that are known to exist at the time the application is filed. So it has to be different than what's already in the market, distinct from that. The second criteria is that it must be uniform. So the variety has to be sufficiently uniform in its relative kind of agronomic characteristics, subject to any just sort of mild variation that could be expected due to the particular features of the propagation of that variety. So the variation has to be predictable and minimal. If it is predictable and minimal, then it is a good likelihood that that variety is actually uniform and will meet that particular criterion. Third criteria is that the variety has to be stable. That means it must remain true to its description over successive generations. So it has to stay stable and consistent in those essential characteristics to the degree that further generations would actually appear to be the same as the initial generations of propagation of that variety. And finally, that variety has to be given a denomination name, which is usually a combination of numbers and letters that is unique to that variety. And that denomination name cannot be a trademark, and it has to be chosen in consultation and compliance with the Plant Breeders' Rights Office's variety naming guidelines. So again, the obvious example here would just be of a plant variety. And here I have a picture for you of CDC forest peas. This is a green pea variety that is protected by Plant Breeders' Rights. So here, just for your reference, and this will maybe be handy for you if you end up taking a copy of this slide deck after this presentation, is just a little summary table of our different key forms of intellectual property, what each of those forms covers, whether or not an application has to be made to actually receive protection as that form of intellectual property, and how long that protection lasts. So different for each, and this is just a quick reference for you. So with that sort of groundwork in mind, understanding a bit about what our different key forms of intellectual property are, how they differ from each other, what they actually confer, it then becomes a little bit more possible for us to think about, within my own organization, what do I need to think about when I'm thinking about protecting the technology, the innovations, the inventions that my organization might actually create or develop? And there's a number of questions to sort of ask yourself when you're thinking about that. Again, we'll dive into some of these a bit deeper in the IP 2.0 or IP 201 presentation that's coming up in October. But for now, I want to just give you a sense of some of the things that you should be thinking about and asking when you're thinking about how to protect the technology that your organization may develop. So the first question to ask yourself is, what do I want to achieve with the technology that is being developed here? What is the goal? What are our objectives in developing technology, and what do we want to do with it? This will guide kind of how you approach protection and lay the groundwork for what you may want to do now and later. If you have technology that you think is worth protecting, you'll want to consider what type of protection is actually applicable and appropriate for your technology. And then you'll also want to think about if you're prepared to manage that protection. So what resources do you have available in your organization to kind of deal with the management and maintenance of protection of your technology? So there are a lot of considerations here, and they will be unique to your organization and are often worth some discussion, both internally and with external advisors that may be able to help you. Not all forms of intellectual property protection are going to be applicable and available for all technologies that you may develop in your organization, and understanding what is applicable and why, and even if it is applicable, whether it's right for that technology, is a discussion that needs to happen. So some specific questions that you can ask to help determine the best method of protecting your technology are kind of as laid out here for you. So determining who played a part in development of that technology is really important, because this can impact who actually owns the technology. If somebody has contributed financially to its development, for example, they may have or believe that they should have some sort of interest in that technology, whether that's ownership or otherwise. Another question is considering kind of who actually owns the technology. That may be driven a bit by who was involved in the development of that technology as well. So do you have inventors? Do you have consultants? Do you have funders? Ownership is often driven in large part by creation, but that isn't the end of the story. And so considering those first two questions together will help you determine how you would even want to think about ownership and what that means in terms of what type of intellectual property protection you may want to seek and how you can seek it. Consider what your goal is with respect to this technology. Is your goal, for example, to be first to market? So just get that technology out the door into commercial channels as quickly as possible, strike while the iron's hot, generate revenue quickly, and then just sort of dissipate from the market quickly? Or is it to create long-term value? So to have a longer-term picture for what that revenue stream could look like, a longer-term usage pattern for your technology. The answer to that will sort of drive what you want to do to protect that IP. Consider if it's worth it. Is it worth it to invest in obtaining intellectual property protection? Or is this a lower value technology where that may not make as much sense? Consider how you will manage that. And I touched on this a couple slides ago as well. Do you have resources available to actually help you seek protection of IP and then manage that protection if and when it is obtained? There is a maintenance process involved with nearly any form of intellectual property protection. And making sure you have both people and financial resources to do that is important when you're considering what type of protection you may actually want to seek. And finally, making sure that you've clarified who is going to be responsible for that management is key to make sure that those maintenance activities actually occur appropriately. Answers to these questions may be driven a little bit by your organizational or corporate IP posture. There are a few different types of IP postures, and what this really means and is referring to is, what is your organization's general approach to intellectual property? How does it view intellectual property and its relative importance to the organization? So is your organization aggressive? Do you use IP as a tool to kind of control the market that you're in? Do you protect, do you acquire intellectual property with the intention of blocking others from doing something similar or maintaining your market position or revenue stream? If you do those things, you may have an aggressive IP posture, and that may impact how you protect the IP that you have. Do you have a proactive IP posture? Are you strategic? Do you plan ahead? Do you make decisions accordingly? Do you have an IP policy or plan? Are you prudently defensive? You may not have an IP plan, but you do think about IP and you're prepared to address any major issues or considerations that may arise there. Are you reactive? You don't think about IP, you don't have a plan to deal with it, and you only deal with it if and when you have to. Or finally, are you passive? IP isn't really a concern for your organization or relevant to it. Where you fall in that sort of continuum will impact how you answer those questions we just went over and how you approach IP in general. So let's quickly go through some common mistakes to avoid, and that I'll sort of leave you with today. First, a few general ones, and then a few specific to the different types of IP that we talked about today. So a common mistake to avoid is failing to document ownership. So failing to really sort of understand and track who was actually involved in the development and creation of intellectual property, and therefore who may have an ownership stake or interest in that intellectual property. So a tip here is to ensure that all contractors to your organization and employees of your organization have either in their employment or consultancy agreement or as a standalone agreement, some sort of intellectual property and confidentiality agreement that sort of addresses who is going to own the things that are developed in the course of their engagement or employment, and how will rights in those things they may develop be sort of held or assigned back to the company that is employing that person and funding that development. Keep a record of who was involved in the creation of that IP, particularly with respect to inventions that may be patentable, because tracing that inventorship is critical to supporting a patent application. Another common mistake to avoid is really around the usage of third-party IP. So using IP in a business that was not created by that business, or as an individual, using IP in your execution of your duties that was not created by you in your current engagement or working environment. So some tips here are when you're hiring employees to ensure that they aren't bringing with them and using in your organization IP that they created or developed for their previous employer. If they are doing that, you're going to want to think about how you need to address that to actually allow that IP to be used by the employee in the current organization, if that is even possible. Also, when you're hiring contractors, make sure the contractors sign a contractor agreement, ensuring that anything that they develop in the course of performing their engagement for you is assigned back to you and owned by you. If you hire an individual, make sure that they aren't employed by a third party who may have that same sort of claim in what that contractor may create. Now, with respect to patents in particular, a couple of common mistakes here that I see in my practice. One is failing to maintain confidentiality of the invention before filing a patent application. This goes back to that novelty criterion that we talked about at the beginning of the webinar. Something that is known to the public or part of the public domain can generally not be patented. There are some limited exceptions to that. The general rule is that if an invention is known of in the public domain, that invention cannot later be patented. So maintaining that confidentiality until you're ready to apply for a patent is critical to ensuring patentability. Other common mistakes I see are failing to conduct patent searches prior to getting heavily involved in the development of a new invention to ensure you aren't developing something that the market is already kind of full of and that is already the subject of a lot of sort of patent filings. Neglecting to file in key markets, so filing for a patent where you want to sell or offer a technology is sort of critical. Patents are jurisdiction specific. Getting a patent in Canada does not mean that you have that same protection in the US, EU, Asia, etc. If you have a patentable invention, everyone who does or may know about it should sign a non-disclosure agreement to kind of protect that confidentiality that I mentioned. And I'll remind you that it's never too early to talk to a patent agent or a patent lawyer if you're unsure how to address and handle some of this. It can be a bit complicated, and what you do now can very much impact what you can do later. So being a bit strategic and thoughtful about how you approach handling an invention is really critical. With respect to copyrights, one common mistake that I see is really just using copyrighted materials that are owned by third parties in your business. So you didn't create that manual, that report, that drawing, yet you're using it without some sort of authorization from the actual author of that work. Another extremely common mistake that I see is neglecting to include in those intellectual property agreements with employees and contractors that I referenced earlier, a assignment of copyright and a waiver of moral rights in copyrighted works from employees or contractors that are creating those works in the course of their engagement with your organization. Finally, using open source licenses in software without consideration of what the terms are that are applicable to open source licenses is a very common mistake and can really impact how you can use and disseminate software that uses open source code later on. So really pay attention to terms of copyright licenses and make sure you have copyright licenses for copyrighted works that you're actually using. And if someone is developing copyrighted works for you, make sure they assign their rights to you in writing. With respect to trademarks, common mistakes that I see are people really not doing their due diligence. And what I mean by that is they're not thinking about the logos or taglines or slogans that they may want to use in connection with their business. And if those slogans, logos, or taglines are materially similar to other logos or slogans or taglines for similar products that may already exist in the marketplace. So doing some due diligence regarding a potential trademark before you start using it, building reputation and goodwill and investing in it is extremely important. Assuming that a trademark is available for use just because you think that you thought of it first is not a good assumption. And there are often a lot of surprises that come for companies, 1, 3, 5 years after they start using a trademark, and then find out that that trademark is actually, or a very similar, I should say, trademark is actually used by another organization in a similar market space. And then you have issues of potentially passing off, infringement, et cetera, that you have to navigate through that are complex and costly. Trade secrets, really the common mistake to avoid here is not maintaining that confidentiality. Having those confidentiality agreements and NDAs in place with your employees, with your contractors, and with anyone else that you may discuss your secret with. So prior to negotiations regarding a potential collaboration, regarding a potential license, if you disclose that information that is secret to you or confidential to you without those agreements in place and as minimally as possible, then you actually undermine your ability to claim that that information is a trade secret and to retain that value. So take that protection of confidentiality very seriously. Ensure that you have consistent confidentiality or NDA type agreements in place. Remember, with trade secrets, I always use this phrase, loose lips sink ships. If you decide to maintain an invention as a trade secret, you need to have contractual, operational, and physical controls in place to actually maintain that secrecy. Just calling something a trade secret doesn't make it so. That's where I'll leave things today. Again, just a fundamentals, a little bit of a high level 10,000 foot view of IP. We will dive a lot deeper into this, particularly those commercial considerations in the next webinar in October. And I'll turn it over to Megan now to tell you a little bit about how this ties into PIC's IP program and to let her kind of bring all of this together for you. So I'm going to stop sharing so that Megan is able to share.
Thank you, Crystal. Always appreciate hearing your knowledge and insight in this area, and I trust that our attendees today got a lot of benefit from your presentation. I am going to just quickly pull up a PIC-specific presentation that I will do here. Sorry, 1 second. Sharing fail. All right, I trust that it is up, and Carson, if it's not, you should send me a text and let me know that you're seeing the wrong thing.
Looks great, Megan.
Okay, perfect. All right, so just, a quick note of thank you to Crystal. And prior to opening up the floor for questions, I do want to sort of just address how the lessons we learned today really fit into the work that we're doing at Protein Industries Canada in our supercluster. So I think to start, just a very quick introduction to PIC. Protein Industries Canada, we know that the global demand for plant protein is growing. And to that end, together with our partners, we are investing $300 million to transform Canada's value-added processing sector. The work done within Protein Industries Canada is collaborative in nature. And we often talk about doing business differently to leverage diverse strengths. So as you can imagine, when you're working in a collaborative consortium type of environment, there is a need to consider intellectual property early and to consider it often within the projects. Knowing that there are folks on the phone today who are hoping to engage with Protein Industries Canada, I thought it would be helpful to maybe just touch on the technology areas that we invest into. There are 4 pillars in which our technology investment falls. So the create pillar is really all about creation of high quality protein germplasm from Canadian crops. Our grow pillar is more the digital and machine learning sort of angle to technology. So looking at smart production to improve quality, yield, value, and integration within the supply chain. The make pillar is where value-added processing comes in. So this is new processing technology and product development for further processing of Canadian crops. And then our sell pillar is focused on marketing and commercialization for branding, sales, and export. I think something important that I'll just pause and note here is that I focus primarily on our technology program, but we do also manage a capacity building program. And that's where more of the sort of ecosystem and support for the industry type projects will fall. If you're interested in the capacity building program, we can certainly connect you with the right folks within Protein Industries Canada to learn more about that. So check out our website or reach out to me directly and I'll make that connection for you. But on the technology side, intellectual property is very important. And Crystal talked today about intellectual property posture. And when it comes to IP management at PIC, we look at projects from a principles-based approach. And what that means is we want to understand how intellectual property, whether it's something registered or a trade secret, plays into the priorities of each project consortium member. So if 3 companies are working together, we want to sort of understand what IP means within each organization and how it will be managed collaboratively as a whole. We work with companies to build trust, which is absolutely key for enabling the diffusion of IP. And that our goal in that is to ensure that we're maximizing the economic return on investment that companies are making into the projects that we're doing together. Part of our role is also to increase the platforms that increase the base of knowledge that our members have around intellectual property. And so today's webinar is one example of this. And Crystal mentioned that we're doing a second webinar that's a bit more of a deep dive into IP on October 8th. So we'd certainly hope folks will join us for that one as well. So when we talk about, the nuts and bolts of working on a technology project with PIC, we always start with the discussion of background intellectual property. And a key point that we want people to understand is that our member companies bring valuable background intellectual property into our projects, and that participation in our projects does not encumber that IP. However, we do seek to work with you to understand the importance of any proprietary technologies that you're bringing in to the consortium and to the project, and what the terms of use of that technology will be within the project. That's all documented as part of the project plan. And I think it's important to know that in some cases, we do have project consortium members who have background IP that they're really looking to market and to get out to the broader community. And a mechanism that we are putting into place to do that will be our intellectual property registry. So I'm not going to get into that today, but hopefully at the webinar on October 8th, we'll be able to provide more context for that. So foreground intellectual property really encompasses the new things that are developed through our supercluster projects. So while Protein Industries Canada doesn't own or control, we have no mechanism for ownership of IP out of the projects, we do have an interest and a goal to work with our consortium members to maximize the value of that IP through enhancing diffusion, so use of the IP by industry. We do this working with companies to set forward an intellectual property plan for each project, and these plans are captured in what we refer to as your IP rationale. So an IP rationale is developed as a component of each technology project full proposal that we receive, and it has sort of three parts that we focus on. There's the background IP component, the foreground intellectual property component, and then an overview of the commercialization and diffusion strategy for the technology. The plan put in place for a particular technology project belongs to the consortium members of that project, and our team is here to support you in developing that plan. So the principles that we discussed today are helpful to inform how you might consider management of your background and foreground intellectual property in a project. And as Crystal mentioned, we'll dig deeper into those commercialization approaches at our next webinar. So this is my last slide. We'll pause for questions here quite quickly, but just sort of to close out the discussion around Protein Industries Canada today, we're a catalyst for growth and transformation of the agri-food sector, and connections are incredibly central to the work that we do. Equally important is understanding the path for commercialization for the projects that we're working on to help move Canada forward from being, a commodity provider to being the ingredient supplier of choice. So I will pause here for today. My email is up on the screen. Feel free to reach out directly if you'd like to talk about IP and how it fits in with PIC. But we'll take a few minutes here to let you ask some questions and take advantage of having Crystal on the call today as well.
Awesome. Thanks, Megan. We have a couple questions come in through the Q&A, so we'll run to that real quickly. There's Crystal. She's just hopping back on here. So, Crystal, I guess the first one here, just to start us off, is a question about what's the average length of time that it would take to file a patent?
Oh boy, that is a good question and a bit of a loaded one when you're talking to someone who works in patents. It is extremely variable, and it really depends upon a few things. One, the complexity of the technology that is the subject of the patent application, how crowded the field already is, so to speak, with comparable technologies. The more crowded the field is, the more tricky it becomes to navigate through a part of the patent process in which the patent office is looking at what they call prior art. So what already exists, and how is what you are seeking to patent different from that, and is it different enough? It also depends upon the prosecution phase of the patent, which is how many people object to what you are trying to patent on some sort of basis. So navigating through all of that can take months. It can even take as long as 18 months to 2 years. So really, I would say on the very quick end, probably about a year. On the longer end, 2 years, maybe even a little bit longer. Really depends on those factors.
Wow, that's really interesting. I never really thought it would take so many variables, but it makes sense. I guess as just a follow-up is there ever a lot of concern of, because it is a long timeline, that you should pursue maybe a different IP method to protect, or a different method to protect your IP?
Yeah, sometimes, and that kind of goes back to those factors that I was talking about what's your objective and how quickly do you need to get to market and how long do you want to keep this product on the market. For some companies, what they have may very well be patentable, but for them, the critical consideration is getting to market extremely quickly. And so for that reason, they may be less concerned about having a patent, and it may not make sense for them to wait. Now, that said, you don't have to wait until a patent is issued to bring a product to market. There is a concept that's what we know as patent pending, which sort of allows, to really put it in a simplistic way just for our conversation today, if you've applied for a patent and then placed your product on the market during the time in which that application is being considered, and a patent is later issued at the end of that process, there is some ability to kind of go back in that patent pending period and assert rights during that period. So it's a more complicated consideration, but yeah, it really, what somebody should do depends entirely upon what it is that we're talking about and what their goals are.
Yeah, that makes sense. I think that goes a lot back to what you were talking about with the IP posture, and I think that that really ties in well here. Sticking on the theme of patents, one question that I had written down was, what if there's a way, or what is the way to obtain potentially a worldwide patent? Because I know you had touched on that filing in certain countries, or that your patent's only relevant in one country. What does it take to kind of be global?
Yeah, so I'll just preface it by saying that there really is no such thing as a worldwide patent. What does exist is the ability to apply for a patent as a PCT application, so a patent cooperation treaty-based application. And what that means is that you have the ability to file in multiple jurisdictions, sort of using the same information and the same filing date, even though you may submit your application at slightly different times in different geographies. So again, that's a little bit more complicated and something to dive into more, but suffice it to say that if you think you want to use, or pardon me, offer to sell or manufacture, what have you, your technology in areas outside of your own kind of home jurisdiction, or the jurisdictions in which you primarily carry on business, you may want to submit your application as a PCT application in order to protect your ability to better and more effectively file in each of the countries in which you want to sell that technology. So that is what's often used by companies who have a technology they think they're going to sell in many parts of the world, or that they anticipate they're going to need to sell in a new geography in a short period of time. So, yeah.
That's great. You see a lot of with globalization now, a lot of entering new markets and the difficulty of protecting your IP. So that I appreciate that. Another question that we have from the Q&A from Rob, it's somewhat related to patents as well. He was asking about for a seed variety, can it have both plant breeder's right and a patent, or does it have to be just one or the other? And I guess you can maybe even expand further than just the seed variety in general of, is there value to looking for multiple methods for protecting the same type of IP?
Yeah, so in some cases, it is possible to kind of stack protection, if you will. But I think what's important to remember there is that each of these forms of protection kind of protects slightly different things. So with a seed variety, for example, to protect the variety itself, so the actual, the seed, what you'd be looking at is plant breeders' rights. If you also want to protect some of the components of that seed, so some of the unique genetics in that seed, some of the unique processes used to kind of conduct genetic modification of that seed, for example, then you're probably going to want to patent those pieces. So you may have PBR and patent that apply to the same variety, but they're covering slightly different things about that variety. So in that sense, you can look at kind of stacking protection, but your protection isn't truly stacked because it's really dealing with slightly different aspects of that same product.
That's cool. It's really interesting and insightful that it's a protection from different forms of possible intrusion. So that's really interesting. We have one other question on the Q&A here that said, and I think she was originally when you were going through the original types of IP, and it was a question about where does research fit in the different types of IP, and the example they used was applied research around third-party evaluations of products or processes.
So if I'm kind of understanding that question appropriately, I think what they're asking about is how do you deal with intellectual property protection when you're conducting that sort of research or those sort of evaluation type studies or tests?
Yeah, that's how I understood it, yeah.
Yeah, so again, that's really variable and depends on what the nature of the research is and what is being studied. how the testing party may be using it. But what you often see when somebody is doing an evaluation or just kind of testing out a product in the sort of egg and food space is use of material transfer agreements, which sort of allows something to be provided to a third party for a limited purpose, usually related to evaluation or testing in a limited scope. And when that is provided, the party who is receiving it is granted a very limited license to use it for that way. It doesn't confer any rights of ownership, it just confers a right of use. Am I frozen here?
Yeah, your video may be frozen. If you turn it off and turn it back on, it may come back. In the interest of time, I had two other questions written down. We can get to them really quickly here. The first was, I
shut off my video in the hope that maybe this will help.
Absolutely.
Sorry about that.
Is there a recommended approach for protecting software?
Oh boy, that's a big question as well. Again, that's really variable and depends on what the software does. So I think what I can say is that generally speaking, an organization or a person who is developing software is going to want to take care to ensure that they have asserted copyright in the code that they are writing for that software. But there may also be aspects of that software product that could be potentially patentable, or processes that are coded for by that software that may be patentable. And so whether or not that's an option will depend on what those processes are and what the software does. So generally speaking, copyright is always a consideration, but there may be other forms of IP protection that could be relevant as well, depending on what the software is. So very general answer to a very big question.
That's perfectly all right. It seems like IP in general has, very specific, when it comes to what your IP is and how to protect it, it gets very specific questions. So it's hard to nail down the exact one.
Exactly. As I said, kind of on, I think it was maybe the first or second slide, there is no one size fits all approach here, unfortunately.
Absolutely.
Some general considerations, but lots of specific considerations. Yeah.
Absolutely. Okay, so the last question I had written down was, is there a place, or I guess my question is, how do you know that your IP isn't already being used by someone else, or if you think you've invented something, is there a place that you can check to find out, if it is actually new and something that's not being protected by someone else?
Yes, so with things like trademarks and patents, for example, there is a place to check. There are databases and registries that are maintained by our Canadian Intellectual Property Office that sort of have publicly searchable listings of registered trademarks and registered patents. And so it is always a good idea when you're developing something to take a little bit of time to look around in there and see if there is something that sounds a lot like what you're working on, and thinking proactively about how what you're working on may be able to be differentiated from that. Because the worst thing that happens is putting a ton of work, effort, resource into developing something, and then finding out when you've got it ready to go and you want to protect it, that protecting it may be extremely hard to do, and that you may even be potentially infringing upon somebody else's intellectual property by making use of your own in the way that you hope. So I'll leave you with this. A lot of organizations do things called freedom to operate evaluations or opinions. And what those are sort of reviews of the what exists in the public domain, and an analysis of that to determine how or if what a company is working on is suitably different from that. So
great. Oh, thank you. I think you're right that's something that probably happens all the time, of when you're developing something and making sure that if you are going to protect it, you're not infringing on something that's already existing. So that's good to know.
Sadly, it does happen a lot.
I can imagine.
Yeah.
Well, we're over time here, so just to be friendly to everybody viewing, we can close off there. Megan or Crystal, we appreciate both of you guys for coming on and giving us this insight today. I would like to say one last thing that we've mentioned all along, there's IP 2.0 webinar on October 8th. You can find the registration at proteinindustries.canada.ca. So please, if you're interested in learning more and expanding your knowledge, join us then. Megan and Crystal, thank you again. And if you have any closing comments, please, by all means.
Yeah, just want to say a final thank you to Crystal for your time today, and also to all the folks who joined us for the call. I hope that you learned something today. Would be pleased to hear from you and continue discussing any questions you might have. And thank you all.
Thanks very much. Thank you for having me.
Bye-bye,
Thanks,
everyone.
everybody. Bye.